It's not surprising that federal courts see cases like these, because often lawyers make mistakes. They miss deadlines. They file the wrong petition. They mess up. Mistakes are made. They miss key facts that would have been helpful to the client when they draft the petition. So it's important in federal cases involving these kinds of questions for the court to be able to draw a line between, on the one hand, ordinary error or ordinary malpractice, in fact, and circumstances that mean that effectively, if not formally, the petitioner was not represented by counsel. What I'd specifically like to talk about is an upcoming Supreme Court case in which, as a scholar on the law of agency and aided by very excellent legal counsel, my colleague Walter Dellinger and his associates at O'Melveny and Myers, I prepared a brief for the court in an effort to help the court understand the possible significance of the law of agency and the assistance that the law of agency might provide in this particular case. This case involves a man named Corey Maples, who was a prisoner on death row in Alabama, having been convicted of murder in Alabama some years ago. Mr. Maples is before the court seeking the right to pursue a federal remedy, specifically a writ of habeas corpus. If he's successful, he would have a hearing in federal court at which he would be able to attempt to demonstrate that his counsel at the trial stage of his conviction and his death sentence, that his trial counsel provided constitutionally ineffective assistance of counsel. So the stakes for Mr. Maples in this case are very high indeed. For reasons that may become evident as I talk about the case a little bit, the stakes for the appearance of integrity of the legal system are also pretty high. Mr. Maples's earlier counsel challenged his conviction, seeking post-conviction relief from the conviction in the Alabama state courts. The Alabama court denied the petition for post-conviction relief and sent letters to that effect, or the court of the clerks sent letters to that effect to the counsel who then represented Mr. Maples. These were two associates in a very large New York law firm and local counsel in Alabama. By the time the notifications arrived at the law firm in New York, the associates had already left to work elsewhere. The two departing associates did not notify the court of their departures, nor, it would seem from the record, did they notify Mr. Maples. When the letters with the notifications of the denial arrived in the mailroom of the law firm that they listed as their address, the mailroom returned the letters to the court, stamped, returned to sender, in one case hand annotated, left firm. Mr. Maples also had local counsel of record in Alabama who did receive the letter and the notification from the court, but put it in the file and did nothing. So what is the practical significance of this from the standpoint of Mr. Maples? Mr. Maples, by virtue of no appeal at the state level having been filed on his behalf, therefore, one, did not appeal on the state level the denial of state post-conviction relief, and the failure to do so cut off his right to seek federal habeas corpus relief. And what might agency doctrine contribute to this? Well, I would say the most fundamental duty that an agent has, including certainly a lawyer, is one of loyalty to the client. or the principal, if this is not a lawyer-client relationship. The brief develops the point that Mr. Maples's counsel could be argued to have abandoned him, effectively leaving him, in a real sense, with no representation. And it's the argument of the brief that the court might use this as a line of demarcation in distinguishing between disloyal conduct, other conduct amounting to abandonment, and simple error, we might say. Because we might think, what could be more disloyal to the client than, without notice and without seeking the substitution of new counsel, to leave the client effectively with no representation at all in the particular matter. But this is a friend of the court brief. This is for the court to use or learn from if it sees fit, and it is, of course, the court's decision. The case will be argued on the second day of this October's term before the United States Supreme Court, October 4th.